Welcome to TFE Talks, Navigating Wealth, Business, and Legacy, the podcast from Thomas Fisher and Edwards. Each episode, our attorneys bring you expert insight on estate planning, business strategy, and legacy building, breaking down complex topics into clear, actionable advice. Whether you're solidifying a strategy we've discussed or preparing for what's next, this podcast is your resource for thoughtful, practical planning. You ready? Let's dive in.
Hello and welcome to another edition of TFE Talks. I'm your host, Jordan Goewey, joined again today by Matt Edwards, a shareholder here at Thomas Fisher and Edwards in Greenville, South Carolina. Matt, thanks for joining me for what should be a very interesting and slightly different topic for us today.
Thanks, Jordan. Happy to join you.
Yeah, so today we are going to talk about firearms in estate planning, or as I presented it to you when I asked you about this topic, welcome to the gun show is our goal here today. And so before we get started, I think you wanted to kind of note just sort of a disclaimer about what we're focusing on and just our expertise in this area.
Absolutely. Two disclaimers, really. One, I am not a gun expert. If I use terms that are slightly incorrect, I know that there's a very enthusiastic group who are fans of firearms and the firearm terminology. I will probably use some of the terms incorrectly. Also, I'm an estate planner, tax attorney, and business attorney. I am not an expert in firearms law, but this does intersect with our areas of law in a number of ways, and so we have to address this, and there are times where, like certain areas of law, I'll reach out to an expert specifically, but most of the questions that we see, we can help our clients with.
Yeah, absolutely. And it certainly is important for us to at least have a working knowledge of this, and we're going to try to share a working knowledge with our clients here today and with our listeners, because we live in the South, we live in America. We are going to have clients, I'd say the majority of our clients own at least a firearm or often multiple firearms. And sometimes they tell us about those, sometimes they don't, but it is property that they own and something that we have to take into account with respect to their estate planning. And so let's start there, and this kind of seems like a silly question off the start, but what is a firearm in the estate planning context? How is it classified for estate planning purposes?
Sure. So for our purposes in the estate planning world, a firearm is just another piece of tangible personal property, something that you could pick up and carry that's not affixed to the ground and is not what we would call an intangible, like money or a financial account or a stock. These are things that you could hand to someone, and our documents generally address those by saying either these items go to this person, or very commonly we have where clients will leave a written memorandum outlining where these specific items would go at their death.
Yeah, and so a firearm is tangible personal property like watches, clothing, furniture, jewelry, and in some cases maybe it can be handled just like those other items of tangible personal property. But I would imagine that in some cases there are probably some limits on transferring firearms, and maybe it depends on the type of firearm. So can you talk some on that?
Absolutely. So most of our firearms, our classic, you can walk into a gun store and walk out the same day with a firearm. It's just an item. Mm-hmm. We assign it to a revocable trust, or we will use a memo that will avoid probate on that. Like you said, it's just like furniture. But there are certain restrictions that are applicable to these items. Some of the restrictions are based on the item itself, and some of the restrictions are based on who may be receiving those items. So let's talk about the items themselves. The National Firearms Act and the Gun Control Act, which are federal laws, address that there are specific types of items that the federal government has a particular interest in regulating. Those are generally suppressors or silencers, short barrel rifles and shotguns, machine guns, and a class that's really described as any other device or destructive devices. So the government has specific definitions for each of those. We've probably seen movies where we see each of those types of things with a certain amount of fiction attached to them, but they exist. They're out in the wild. There are also some collectible items that have a different set of rules, and to a great extent are outside of the federal regulations. But every time we look at a firearm, we need to categorize it. Is it a normal firearm, or is it a specially restricted firearm?
And so you mentioned that is a national act, that's a federal act that applies to those. And so does that then deal with the ownership of those, just the transfer of those? What sort of general limitations does that place on those sorts of firearms?
So for that class of items that's often referred to as NFA items, National Firearms Act items, those items, to be transferred, the government has to receive an application for transfer and approve that transfer, mainly based on who the transferee is. They will do a background check. There's an application, and for the type of item, there's a varying fee, a tax that's associated with that. In the past, there was a $200 fee for most of these items. Currently, that fee for most of these items is zero, but it's still an application process. The government takes a certain amount of time to transfer, allow that, and only once the government approves it do we effect a transfer of those items.
Is that something that can be pre-approved? Like if someone is going, we're talking about estate planning, if they're going to transfer their firearm to a particular individual when they die, which could be tomorrow, it could be years in advance, can they get that pre-approved?
Generally not.
Yeah.
Generally not. There's some particular rules associated with gun trusts, but generally no. It's at the time of transfer that we're testing all of these things.
Gotcha.
And so for our estate planning, we'll sign documents, and years later, they will go into effect when somebody dies or for certain things becomes disabled. And so we have to go through that process at that time of transfer.
And so that's on the federal level. How about on the state level? Are there state law considerations that come into place with firearms? And does it depend on the state? Or if you have someone that dies in South Carolina but they have a beneficiary in another state, how can that all affect things?
Sure. So each state has its own set of firearm laws. South Carolina is generally among the states very open and free with its laws. Some states, California, New York, have very restrictive laws about gun ownership, storage, who can possess. Every state, we need to evaluate whether a recipient can receive that item, possess it, either in their own right and particularly in that state. There's also a host of rules about shipping items and how they can be received. We need to be very careful to transfer items through the appropriate channels, often using what's called an FFL, a Federal Firearms Licensee, for interstate transfers on that. So every time we have one of these items that we're transferring, we evaluate the item, the transferee, and where it's going in that situation.
And so for these specific types of firearms, there are these different considerations as far as who the transferee is. Another question I have, and maybe this is one that doesn't really depend on the type of firearm, but just for any sort of firearm, but what if a beneficiary is a minor or someone who maybe we don't want to have a firearm immediately? What types of additional considerations come into play at that point in time?
Federal law will limit who can possess certain items, certain ages, and generally for valuable or dangerous or items that may have items that may have certain liability attached to them. Usually, we don't want to give minors direct ownership and possession of a firearm. Certainly, we see granddad's shotgun wants to go down. Granddad wants that to go to his grandson, who may be of a young age. We recommend that be held back for the individual until they reach the appropriate age in the hands of a custodian or trustee, or just deliver it to an adult who that it becomes their item, that our client has confidence that at the appropriate age they will transfer it down to the next generation.
Yeah, and that's a really important consideration on, whether someone can own any asset, but particularly a firearm if they're a minor. And kind of a related question that I would have is, we sometimes talk on this podcast about how estate planning really starts during your lifetime. So if there's an individual out there who owns a lot of firearms or owns a number of firearms and they became incapacitated, what happens then? Can their agent under a power of attorney take possession of those firearms, or what consideration should that agent have to protect themselves and protect the principal who became incapacitated and is the owner of those firearms?
In an incapacity situation, again, these items, setting aside the NFA items,
Right.
these items are just assets. And our agent under power of attorney can take possession, has an obligation when they step into that role to secure the items, make sure they are protected. The items are protected themselves from loss, but also those items can't get into the hands of someone who could hurt themselves or someone else with them. It's an obligation that we recommend for our fiduciaries, that if they know that there's a collection of items or even a particular item, whether it is a collection of firearms or a valuable painting or jewelry, that they secure and inventory those items when they're acting as a fiduciary for another person.
Yeah, certainly a smart step there to protect the fiduciary and make sure that they're carrying out their duties. It's not just a passive role where you're only taking action when an asset needs to be sold or an asset needs to be transferred, but also just those day-to-day steps that you take to protect the principal's assets are certainly important. Matt, you mentioned earlier the concept of a gun trust, and can you give us, and again, going back to your disclaimer, we're not experts in this area. I don't think that we really prepare gun trusts ourselves. I have not. But give us an idea of what is a gun trust and when is that something that a gun owner should consider?
Right. So these gun trusts are directed to the NFA items. Our regular revocable trust is what we'll use for, I'll call them the regular firearms.
Sure.
The NFA items, because they have transfer restrictions and custody restrictions, an NFA item has one owner and permitted user. And with that, if I were to have a suppressor, then if I were going to allow you to use it, then I would have to be there with you. I would have to retain custody, essentially. While you could pick it up and fire it, I would have to be there, a part of that. With a gun trust, it can allow multiple owners to have that custody, where we have multiple trustees in charge of that. So multiple people can access and use the firearm. It also addresses in that trust agreement who are the permitted users, who are the successor users in the event that there's a disability. So it does more and has better protections outside of the durable power of attorney, and can have terms for these items, what happens at death. What we've seen for some of our clients and fiduciaries, when we have used a professional trustee, a professional administrator, they very often do not want to be involved with these NFA items because of the restricted laws and perceptions and potential liabilities. And so we may have a different set of fiduciaries in charge of the normal assets, and then a separate set of fiduciaries for the NFA items.
And going back to my question from earlier about, can we kind of get pre-approved to transfer these NFA items, and you said we couldn't do that to transfer them to a specific person at death. But this gun trust is a way that we can effectively bridge that gap when we don't know when death is occurring, obviously, but we want to make sure that there's a very clean transfer.
Right. Those people who are the trustees can be applied to the alcohol, tobacco, firearms, and get approval to be that trustee, to be that custodian
Right.
in that role.
And so, Matt, one final question here, and it really just deals with, what issues gun owners should be thinking about when they're thinking about their estate planning and what's going to happen to their firearms and how will they be transitioned through that process. And really the question just boils down to how can those individuals who are gun owners help us help them with their planning?
Right. We ask our clients, we need to know about these items to develop a plan. And if there are, just the normal guns, maybe it's a valuable collection. We want to put specific rules into the trust agreement. If there may be disputes between beneficiaries as to who's supposed to receive an item, we can advise on that. And if there are these NFA items, we can bring in an expert, develop a plan, because our estate plan is really for the beneficiaries. It's for those administrators when somebody passes away. And so our clients can help us help their personal representative, trustee, and beneficiaries by giving us that information. We keep it as confidential as our law allows, and there's ways in which we can keep the estate administration process more confidential than if we don't know about it.
Yeah, that's right. I mean, we can only help our clients to the extent that we know about their assets. And as I mentioned earlier, I would imagine that a majority of our clients own guns, and sometimes we know about those guns, but sometimes we don't, and we can tell sometimes that they're a little reluctant to list that information on an estate planning questionnaire, and I can understand why to a degree, but we can't plan for it if we don't know about it. Right. And certainly we can't plan for the things that may require special attention, such as these NFA items, because we may need to bring an expert in. We may need to consider a gun trust. We may need to think through that more fully, and we can't do that if we don't know about the items. And so it's always helpful if they let us know about those. And as you mentioned, we can keep that confidential, but we can think through a good way to make sure that those smoothly transition at death or during an incapacity.
Absolutely.
And so thanks for coming on the podcast today to talk about an interesting topic, a little bit of a different topic than what we're usually talking about. This one doesn't really deal with tax planning or anything like that, but it is something that's very important for our clients and our listeners. So thanks for coming on and sharing your thoughts on this.
My pleasure. Thanks, Jordan.
Thank you.
Thanks for listening to TFE Talks. For more information, please visit our website at www.tfelawfirm.com. You can also follow us on LinkedIn, Facebook, and Instagram by clicking the links below in the show notes. If you have any questions about topics discussed in the episode, or you have recommendations for future topics, please email us at info@tfelawfirm.com. See you next time.